I'm George Whipple, one-on-one with Haley Morrison. Haley, good morning. How are you?
Good morning, George.
So you live in Portland, and yet 90% of your practice is in California. How does that happen?
Yes, true. So I started my practice. I went to law school in California. I never would have left, but for wanting to come home and be closer to my family. So I moved back up here as an associate. And as an associate, you think that you are just I thought I would start over. I would take the Oregon bar. And that's what I did. But then slowly but surely, my California clients found me. And next thing I knew, I had a really nice California practice sitting here in Portland, and that has just continued to grow.
So let's talk a little bit about you as a litigator. You're a litigator that hates litigation. What the heck do you mean by that?
Look, any litigator or most litigators will tell you that they love going to trial, that they want to be in the courtroom. I am no exception. That is the ring. I want to be in the ring. I love the fight. But that's not always the best decision for our clients. And I think that we are not serving our clients if we go to the 10th level every single time. And so I will always try to strategize, problem solve, see if there's another route for my client before we go spending all of their money in litigation. I can give you an example I had just recently. I had a client that was a small, well-funded startup. They had irrefutable proof that their head of product, who had gone to a competitor, had stolen some of their IP on the way out the door. So they called me on a Friday morning. I remember it was Friday for very distinct reasons, and said, we need to file a TRO today. Like, our company is going to go under if this competitor steals their IP. And so we were talking about it. Most lawyers, not to denigrate anybody else, but would file that TRO. That's $100,000 by the end of the weekend for the client. We talked the issue through. There was all sorts of reasons not to file this TRO. So I called the GC at the other company, and I left some obnoxious, Friday afternoon voicemail just trying to get him to call me back. But I said something along the lines of, hi, it's Friday. I don't really want to spend this weekend filing a TRO against you. I'm sure you don't want to do that either. Could you give me a call so we can avoid it? Something like that. He called me back, and of course his posture was not happy, and he was a little bit defensive. I think he thought I was trying to play gotcha with him, and I just said, hey, look, I am sure you don't know this. I didn't assume that they had any malintent. And I just said, you hired this head of product. I know he stole this IP from my company. I am sure you don't want that in your company. I'm sure you don't want it on your servers. And if you can get rid of it and get me a declaration saying that you got rid of it, we're done. They got rid of the IP. They got a declaration saying it was gone from their IT. I gave it to my client. The problem was solved. The real kicker about the situation was he called me back about a week later, and he said, why didn't you file that TRO? You could have made a lot of money. And I told him why, and he hired me. So they're my client now, too, because I chose to make that phone call instead of filing the lawsuit. And they ended up buying the original client a couple years later. And had they filed a TRO against him, there's no way that that relationship would have started out the right way. They would have been a protracted litigation. So everybody won. But a phone call, if you can make a phone call and resolve the problem, is way better than running off to court.
The post-COVID world seems to have changed a lot in the workplace. My clients are seeing a lot of mental health related leave issues. Are you seeing that with your clients? And what are you doing about it? And what are you recommending?
We are seeing that so much. It's a different kind of leave issue than in years past, right? It's not the broken arm or the surgery or the thing that you can see, you can touch, you can really understand it. A lot of times it's a stress and anxiety leave, or something that is more amorphous, and it's more difficult to understand the duration of the leave, what it looks like, how it manifests. It's more difficult for the employee to understand what's going on and how they need to take care of themselves, how long it's going to last. So this is one of those areas where our advice and counseling work and litigation really go hand in hand. If you can give good advice up front, then maybe we can avoid the litigation altogether. It's coaching people to have empathetic and careful conversations. It's teaching people how to listen, how to problem solve, how to brainstorm solutions that may not be apparent or the first solution. How can we get to a place where we can return you to work, or we can help you and assist you in the best way possible? Most employees, they sue or get upset with the company when they don't feel heard or when they're angry. And if they feel well taken care of, and if that's really the authentic intention is to take care of an employee, they feel that. And sometimes litigation still happens. That's when I say I'm the litigator that hates litigation. I'd prefer that litigation didn't happen. But we're going to get you to a place where you've done everything you can first for that employee and for your business. And then if we have to defend those decisions, we will.
Well, it's nice to be with you. It's nice to be in the Portland office. It's nice to have your lattes. And I'm George Whipple. This was One-on-One with Haley Morrison.